Good morning. Thank you so much to the organizers and mainly to Panos for this kind invitation, and I'm very happy to be part of this debate over yesterday and today. In 1988, at a colloquium which was entitled Change and Stability in International Lawmaking, organized by Antonio Cassese and Joseph Weiler, Jimenez de Arechaga spoke of customary international law as being spontaneous, unintentional, unconscious in its origin, disorderly, uncertain in its form, slow in its establishment. Other scholars ever since have spoken of customs, method, and process as chaotic, unstructured, and politically charged, in which the participants make and respond to competing claims on the law as they advance their own agendas. International courts and tribunals have greatly contributed to our understanding of customary international law and its infinite variety and complexity as a source of international law, but they have not really settled on the methodology of customary international law. In fact, in many ways, their output, which is the only thing that we can objectively assess, meaning their reasoning, may have added, in fact, some ambiguity by mixing various aspects of the analysis of customary international law. I would say it is almost like mixing different ingredients at a wrong order, or rather at a wrong timing when one wants to bake a cake. The cake is only delicious if the ingredients come in the right order and in the right proportion. Of course, I'm not a baker, but as a lawyer, one is left with a sense of frustration when actually in detail reviewing some of the judgments of the international courts and tribunals dealing with customary international law. And the basic ingredients, obviously, like state practice, be it a flour and opinio juris is a butter, are the same across the board, albeit sometimes given more or less emphasis in terms of proportion, whether it depends on the subject area or on other considerations that a court or tribunal may have. But courts and tribunals have certainly had and shown the tendency to conflate in their reasoning the three, at least analytically, different processes: that of identification of the existence of a rule of customary international law, the interpretation, and the application of that particular rule to a given set of facts in a dispute pending before the court or tribunal. So what I'm going to try to do in the 15 minutes is really to go through the problematique and from some concrete examples from the practice of international courts and tribunals, and try to convey to you that there is a problem in this lack of theorizing the methodology and its consistent application in the practice of courts and tribunals, and what could be the way forward. So obviously I can skip the definitions, but the key ingredients are there. It's been a while that we are all familiar with state practice and opinio juris sort of go hand in hand as it were a married couple. It is almost like an evolution if you look into customary international law, in particular in the way that the court has construed customary international law. It's almost like an expansion of the concept of marriage, as we have witnessed it in various societies. Perhaps nowadays it's not quite the orthodox marriage that we may be familiar to if we look into 1969, North Continental Shelf. Maybe it has evolved something into a broader scheme of partnership post Libya, Malta, and Nicaragua case. And so we've kind of promoted really the equality between the two elements in the custom identification. And so that has led over time scholars to try to think thoroughly through, okay, what are the different methods which are being applied by international courts and tribunals? In essence, we have now sort of laid down our foundations on that there is an inductive, deductive, and quite often pure assertion, as Stefan Talmon quite critically has argued in his Egil piece. But is it really all? And this is where, sort of, if you start thinking about it in different steps of analysis, and I think this has recurrently come throughout this conference, perhaps there is an added value in breaking down the scheme, by at least three different steps of analysis, being identification, interpretation, and application of customary international law. At least that's what the courts can do. Obviously, the formation question, I maybe have a slightly different view from Jörg, but we can discuss that later. The question is, are we actually having some sort of mélange de genre? And here I'm borrowing Argos' concept from a different discussion. Should we really care about devising, spelling out the methodology and actually applying it consistently in respect of these distinct steps of analysis? Nothing better than just going straight on into some of the cases. Jurisdictional immunities of the state is probably what I would call the closest one comes to a methodology announced and applied and followed. But even here, problems arise. If you look carefully in those 5 or 6 pages of the court's analysis of customary international law, and not even so much about the customary rule of state immunity, but really on those 2 exceptions that Italy was pleading. Because one, I mean, obviously I won't have time to develop in terms of facts, but we can discuss it later. One was the territorial tort exception, and the other one was the jus cogens exception. So look here for the example of the reasoning on the territorial tort exception. It's a fantastic conflation of what we are really talking about. Are we trying to identify customary international law? Are we trying to precise the content by looking where there is an exception which has found some credence and practices and an opinio juris? And the court itself, quite surprisingly, out of a range of various aspects of evidence of state practice, starts its analysis with the European Convention, the Basel Convention, and the UN Convention, which, I will remind you, wasn't even enforced, and still is not even enforced. And so it's quite surprising. And the court then says, well, the provisions of these conventions are therefore relevant only insofar as they are provisions, and the process of their adoption and implementation shed light on the content of customary international law. So we're kind of already moving a step beyond in terms of really interpreting what is the content here, whether these exceptions and how they would be operationalized, by looking as a first step into these conventions rather than really into the practice which subsequently the court analyzes. Interestingly enough, again, sort of my transition from marriage to partnership, if you look then later on, paragraph 77, court devotes only 2 lines to the opinio juris, deducing it from generalized silence of states participating in the negotiations of these 2 conventions. Fabulous. Then there is another sort of recurring theme. Homework done, but not demonstrated. Yes, you should believe us. Homework has been done. These cases, like Ahmadou Sadio Diallo or arrest warrant, are perfect illustrations. Again, if you look really carefully into the reasoning of the court goes on, and this you will be recalled, the Guinea's argument that over time there has been now, including thanks to the proliferation of treaties, bilateral investment treaties, we can now think of an exception under customary international law allowing for protection by substitution. So basically, if the shareholder is of your nationality, the court comes out and says, well, the court, having carefully examined state practice and decisions of international courts and tribunals in respect of diplomatic protection, nowhere to be found, even opinio juris here. The court seems to be talking just about state practice, and then goes on to say, well, for the time being, these do not reveal an exception in customary international law allowing for protection by substitution. And the court then in subsequent paragraph goes on to say that the existence of these various treaties is not sufficient to show that there has been a change in the customary rules of diplomatic protection. So we are now trying to really identify whether there has been a change and sort of evolutive process in the existing customary international law. So, and then we have, again, the court coming out in the arrest warrant case, saying simply the court has carefully examined state practice, including national legislation and those few decisions of national higher courts, and was unable to deduce from this practice any form of exception to the rule that accords immunity to incumbent ministers. And then there is a fabulous evolution even further in terms of the sort of complete pull away from any methodological rigor. If the parties agree that something is custom, then definitely it must be customary international law. And the territorial and maritime dispute between Nicaragua and Colombia is just a rich and full of wonderful examples of the court really extending the sort of the scope of customary international law on a number of aspects, and simply on the grounds that the parties to a dispute before it seem to have agreed that this is customary international law. Well, that is far away from what at least the orthodox methodology of identification and application of customary international law should be about. Fabulous example here, which connects the previous sort of tendency of the parties agree, so it must be CIL. It's a CIL because we have said so. Now, if you really start backtracking the chain of causation to where it starts from, you realize that that initial statement of the court, nothing of a sort of practice opinio juris was even introduced to justify the conclusion. And here the court goes on further, saying, well, we have previously spoken about the customary law character of Article 121, paragraph 1 and 2 of the UNCLOS, but now we extend this because the whole regime of Article 121 on the islands and rocks is part of customary international law and forms an indivisible regime. And then, of course, we have the fabulous and the easiest way around any sort of methodology, CILC, CIL. That is really a fantastic approach that the court has taken in a number of cases, like Gabčíkovo-Najimaras, and this be reminded that this was still even in relation to a draft, a work in progress, or Bosnia genocide, reflecting a customary international law, and yet the court then goes for paragraphs in applying and giving meaning and content to the rule and interpreting the scope of that rule, even though on a number of those elements there was, at least at the time, no consistent practice or opinio juris. And then we have some other courts. Well, isn't it even easier for them? CIL is what the ICJ says is CIL, and you have perfect illustrations of that in cases such as John the United Kingdom before the European Court of Human Rights. Well, why should we bother really going over state practice and opinio juris if the court has already said so? Efficiency of means. Perhaps that is the best methodology to be applied for the future. And then we have even better examples of complete, diminishing of any methodological rigor, like we can find them in investment treaty context. No customary international law would mean non-leakage. Hence, we have to say it is customary international law. Well, that is, I think, that is bringing us really to the outer limits of what the law generally, not even customary international law, should be about. And then we have usual examples of peer pressure, like EC Biotech, which was mentioned earlier today by Panos. Well, if the appellate body has previously in EC Hormones taken that position, if we don't find any authoritative decision of any other international courts and tribunals, hence, I guess, precautionary principle, precautionary approach is to remain that we shouldn't get into ascertaining whether the practice has, or in opinion juris has or has not evolved ever since. So why does it all matter? And obviously I have 1 minute, so we can discuss it during. But why does it all matter? First, I think there is clearly, if you look into the jurisprudence, a circle of trust. ILC, ICJ, other international courts and tribunals, sort of cross-referencing, and then this comes to domestic courts, who just buy it, and they themselves and their judgments become state practice. So we really full-on close the circle. And then, of course, this matter because courts are acting as either agents who would be progressively developing customary international or actually leading to regression. You have examples of assertion of customary international law without any at least expressly stated evidence, assertions of customary international law, oh, I think my time is out, relying exclusively on precedent, and assertions of customary international law relying exclusively on the ILC, and thereby having a risk of really foreclosure and prejudging the content and scope of any particular provision, even in the absence of settled practice and opinio juris at the time. So I may discuss this later, I obviously ran out of time, but I do think that we should think very carefully about what we want for the future of customary international law as a source in itself. If we have a less rigorous application of the methodology, this of course may allow perhaps greater flexibility and efficiency of means for the adjudicators in their reasoning. But the greater care in the methodology will, in my view, lead to greater acceptance of that decision and also to really building a much more sophisticated argumentation around customary international law. Thank you.